Okay, so as you can probably see from all of this drawing that we've done, this entire system is a bit of a mess. And one of the most challenging aspects of legal research is trying to figure out if the primary sources of law that you have found are even good law. And so let's discuss the process for determining whether law is good or bad. And we call this process updating. And updating, as you may recall, when we talked about finding primary sources, right? So you find a case, or it could be a constitutional provision, it could be a statutory provision, it could be a regulatory provision, or a case, and we can look at how future cases have interpreted that or have cited that case. So this is looking into the future, and these are the citing decisions, right? The citing decisions. So these citing decisions are cases that came after this case that cite this case, and we thankfully have companies that keep track of all of the citations of all of these different court cases, and then use a tool called a citator to determine in order to lead you to those cases. And just as a citator is a useful tool for finding citing decisions, it is also your most valuable tool in uncovering bad law. So recall that for Lexis has its Shepard's tool, and then Westlaw has KeyCite, and these both provide you a list of citing decisions, and you can use those citing decisions to see if future courts have either overruled or reversed, or even if the case has been uh, declared superseded. So this is frankly a challenging thing to do manually, because it would require you to sort of individually look through each of the cases that have cited the case that you're looking at, and reading each of those decisions to see if any of them have stated that the case has been overruled, reversed, or superseded. Uh, fortunately, fortunately, these citators try to make it easier with little signals that will tell you if it looks like a case is bad law. So Shepard's has the red stop sign, and then Westlaw has the red flag. And both of these are indicators that some future citing decision of the case that you're looking at has said there's a problem with this guy. And so that is usually the first place to start if you are trying to update a case. If you're trying to update a case, and you can also use this citator tool, and the Shepardizing and the key cites, to update statutes, regulations, and even constitutional laws to see if they have been declared preempted or unconstitutional, or if there's some other issue that would make that law to be bad law. Superseding Superseded by statute is a little bit harder than the others to detect, because the statutes, you don't necessarily know right away if a statute is superseding a court's interpretation. Various code provisions get amended frequently. It doesn't necessarily mean that the amendment is affecting uh, a court's interpretation. Um, but fortunately, both of these citators are actually pretty good at identifying when pending legislation could affect a decision that interprets a statutory provision. And in any event, even if they don't, it's fairly common for a court to actually eventually will make a decision that states uh, uh, that such and such precedent has been superseded by statute. So this is where we say that it's been declared superseded by statute. Now, unfortunately, as good as Shepard's and Keysight have become at identifying when a case or other law has become bad law, they are not perfect. And so, what we call negative treatment, which is the indicator that both Shepard's and Keysight are looking for, so negative treatment, is unfortunately not always fatal. Not always fatal. There are many times that a case will be overruled by a future citing decision, but it will only be overruled in part. And in fact, that's probably more frequent than an entire case being overruled in whole. Because appellate court opinions often are dealing with multiple issues and analyzing multiple issues and deciding multiple issues. And when they are later overruled, the future court is only overruling its decision on one of those issues and leaving the rest of the case intact as to everything else. And so when you see negative treatment, what you have to do is you have to look at what the future case actually said about the case that you're looking at to see if any of the decision remains intact as good law, because oftentimes it's just one or two issues or decisions that have been declared to be overruled. And the same thing will happen with cases being superseded. Uh, Frequently, when it's superseded, it doesn't supersede the entire decision. It's only dealing with one particular provision that was interpreted by the case. But even in that matter, even when a statute does supersede a decision, it's only really superseding it as it applies to that particular statutory provision. And the rationale that the case used in making its interpretation might well still be valid to apply by analogy to other statutory provisions. So, like I said, a lot of times negative treatment is not fatal to the entire case. And sometimes you can sift out certain aspects of the case that are still citable. However, the absence of a indicator of negative treatment is also not always accurate. So I have in my career uh, found cases in Westlaw and in Lexis that didn't have a red stop sign, didn't have a red flag, that I still found to be bad law. And that can happen for a number of reasons. Um, first off, it can't just be a mistake by the citator itself. Um, we are dealing with a system of law that is not very organized, and a citator can only do so much to try to bring a semblance of order into this chaotic system. Beyond that, however, you can also just get situations where the citator uh, just isn't able to really reliably detect instances where a certain case might become bad law. That's especially true when it's being superseded by statute. Oftentimes statutory amendments just don't give a clear indication that they are superseding a a case. And it's also possible that you have an interaction between multiple statutes that don't make it self-evident that a statute is superseding a case. So I'll give you an example. So in Washington, there is a rule regarding misdemeanor arrests. Misdemeanor arrests. And this rule says that in general, an officer cannot arrest a person for committing a misdemeanor unless the officer personally observed the crime being committed. There is another only slightly related rule called the fellow officer rule. Fellow officer rule. And this rule states that an officer can arrest someone even if they don't have probable cause to arrest, so long as some other officer does have probable cause and sort of relays that information to them. So if one officer has probable cause, he can ask another officer to make an arrest, and that will be a lawful arrest so long as the first officer has probable cause. And so there was a case where one officer observed a a bad guy committing DUI, and DUI is a misdemeanor. And then this officer relayed that information to a second officer, and then that second officer made an arrest. Okay? So the first officer witnessed it, and then the second officer made the arrest. And the court in this case ruled that this was an unlawful arrest because regardless of the fellow officer rule, the fellow officer rule did not negate the misdemeanor arrest rule, and it said that since this second officer had not personally witnessed the DUI, he could not make a misdemeanor arrest. Only the first officer could. Okay? And so it decided that that was an unlawful arrest. Subsequent to this decision, the legislature passed a law that put DUI, so let me, subsequent to this decision, the legislature puts DUI on list of arrestable misdemeanors. And by doing this, it said that since the DUI is no longer going to be operating under the misdemeanor arrest rule, then naturally an officer can rely on the fellow officer rule to make an arrest. But because this case was about the fellow officer rule, and this statute, let me do different colors here. So because this case about unlawful arrests dealt with the fellow officer rule, while this new statute dealt with the misdemeanor arrest rule, the citator didn't make the connection that this case had been superseded by statute. And notably, it was still good law with respect to the fellow officer rule, or excuse me, with respect to the misdemeanor arrest rule. It's just it didn't apply now because DUI had been taken out of the misdemeanor arrest rule by the legislature. And so a lawyer that I knew cited this decision in court, and the judge basically said, well, that's actually no longer good law because the legislature passed this statute. But unfortunately, that's a pretty easy mistake to make unless you are very familiar with the evolution of DUI law in the state of Washington. And just doing legal research without that background knowledge, you probably wouldn't be able to easily determine that this great case that you had about that was all about the fellow officer rule didn't apply to the circumstance just because the legislature had passed this new statute. And importantly, it didn't. There was no red stop sign or red flag on the Shepard citator or on the Keysight citator. So this new statute sort of slipped through the cracks. So how can you avoid this? Well, the reality is that it's not possible to be 100% certain that a law is good law all the time. And I would say that it's even perhaps a rite of passage that every lawyer at one point is going to go to a court with a great case that they found uh, that should win them their argument that they later discover is now bad law. But there are ways to mitigate the odds of citing bad law, and the best way to do that is first remember the hierarchy. Okay, if you have a Supreme Court case that is interpreting, let's say a federal Supreme Court case that is interpreting federal constitutional law, Okay, so let me write that out. Federal Supreme Court case that's interpreting federal constitutional law. This cannot be superseded by statute. It could potentially be superseded by a constitutional amendment, but the federal Supreme Court is the highest court, so it can't have been reversed. It's not going to be superseded by statute, and there's a really good chance that if it had been superseded by a constitutional amendment, that you would have heard about it. So you can use your hierarchy to really look at what are the odds that this law has become bad, just by looking at where it sits on the hierarchy. The second is look for recent citing decisions. So in this case that we talked about is the case that sort of evaded the citator, because it wasn't exactly mapping onto the decision of the case. Um, you can instead look for recent citing decisions. And if this had been a case, say from like 1980, and it had never been cited again, then that could be your own red flag that this may no longer be good law if it hasn't been cited in a while. Um, on the other hand, if you're finding recent citing decisions that are pointing to this case that you found with favorable language, then that's a pretty good indication that it is good law. And then the third is be weary of staking claim on one case. And that probably was the the most significant error with this attorney that cited the case about the fellow officer rule. The claim was basically entirely dependent on this one case, and if you're dealing with something that is entirely dependent on the one case, that's where you've got to be really careful, because if that one case turns out to be bad law, then there goes your whole argument. But beyond that, it's also the case that if if you only have one case that helps your claim, then that is itself an indication that law may not be reliable. And if you find yourself in this position, you have to be really cautious to make sure that it is still good law.